Good morning, everybody. I call to order the Tuesday, June 17th Judicial and Public Safety Committee meeting. Can I get a roll call, please?
Member Childress, Member Desart, Member Eckhoff, Member Evans,
Here.
Member Heather, Member Honig, Member Krajewski, Member Ozog, Member Shorzy, Member Tornator,
Here.
Member Yu,
Here.
Member Zay.
Okay, we have a quorum and there is no public comment. Okay, so for chair remarks, good morning, everybody. We do not have a lot of items on the agenda today, but we do have a recognition for a retirement, and we will address that in a moment. And we're going to have at the end of the meeting a presentation from our state's attorney, Bob Berlin. So we're going to wait and yes, so we're going to go with the items first, and then we'll come back to our retirement. So let's go to approval of minutes. Can I get approval for the regular meeting minutes, Tuesday, June 3rd, 2025? Okay, all in favor? Any opposed? Okay, the motion carries. Moving on to procurement requisitions. You know, I need my glasses. Can I get a motion to approve JPSP 30-25 recommendation for the approval of a contract to Kelly Graham to design and implement comprehensive job placement for unemployed probationers for the period of June 30th, 2025 through June 29th, 2026 for a contract total amount not to exceed $32,000. Okay, we got a motion and a second, and we have discussion. So I'm going to start with Member Eckhoff.
So I had the same question for 6A and 6B. Have we done these programs before? And if so, I didn't see anything that showed what the success rate is over time.
Okay, is anybody from the coroner's office, or not coroner's office, the probationer's office on the line? Oh, I don't know why.
Aye.
Oh, the microphone.
No one's ever told me they can't hear me before. But good morning. So in response to your question, yes, both of these programs have been done previously. This is a contract renewal for both. And in terms of success rate, I don't have the specific numbers, but yes, there are quite a number of recovery coaches that are placed with Lauren for people who are being linked with community support for long-term recovery. And then Kelly Graham has been our longstanding employment coordinator who works with neighborhood employers to connect probationers who are out of work or underemployed with meaningful work in the community. So yes.
All right, because I saw that we interviewed like 2 other people for that position. So if just between now and county board next week, can we get some information about
Certainly.
how many people they've helped and
Sure.
how far out they check to see how that person's doing? Because I know it's easy for maybe the first 6 months or a year for the person to do whatever they coached about, but see how they're doing 2 or 3 years out.
Most certainly.
All right, for both of them.
Yep.
All right, thank you.
You're welcome.
Members, you might want to stay up there because Member Zay is gonna, Kathy, Member Zay.
No,
has-
that
oh,
was my same question. I just, because it said design and implement. I didn't know if it was new
Oh.
or we were just, but
Sure.
sounds good.
Okay, thank you. Any other questions or comments? Okay, all in favor? Any opposed? Okay, the motion carries. Moving on to, can I get a motion to approve JPSP 31-25 recommendation for the approval of a contract to Lauren McLaughlin as a recovery coach coordinator to work with Serenity House and Path to Recovery coaches, probation, and other stakeholders to provide services to the participants in the program for the period of July 1st, 2025 through July 8th, 2026 for a contract total amount not to exceed $45,000. And this is for probation and court services also. Any questions or comments on it? Okay, all in favor?
Aye.
Any opposed? Okay, the motion carries. Moving on to resolutions, can I get a motion to approve FIR 104-25? Additional appropriation for the Title 4D grant SFY 26-27, intergovernmental agreement number 2026-5513 IGA. And that's for our state's attorney's office in the amount of $1,629,842. We got a motion. Did we get a second on that one? Okay, we got a second. Any questions or comments? All in favor? Any opposed? Okay, the motion carries. Can I get a motion to approve JPS R-9-25 memorandum of agreement between the Compass Church and the County of DuPage for the use of facilities to service as a disaster relief center / shelter, and this is for OHSEM. Got a motion a second, and Member Zay.
Yeah, thank you. I was just wondering how many of these agreements do we have and how many disaster relief shelters do we have on the books? I know we used to have Benedictine in some other places. I just wondered how many more we have.
Randy.
Good morning, members. These will be our second and third. Benedictine is our only agreement in place, has been for about 20 years. And this adds 2 more to the county.
Okay, great. Thank you.
Okay, we have Member Desart.
Thank you. I was just wondering, there are so many Compass churches. Is this for just the Hobson Road one and the one in Wheaton on Roosevelt? Or are all of the Compass churches allowing us to use their facilities?
These agreements are specifically for these 2. That's
Just
not to
those
say we can't ask for additional ones.
And what exactly are these used for?
These would be,
Would it be like the tornadoes, the Father's Day tornadoes, where we handed out supplies at the elementary school, or is it for people to sleep, or what are these for?
it could be for both and more. So we encourage every municipality to have its own local shelters first. So I sometimes refer to Benedictine or these 2 now as a shelter of last resort. So for a large scale mass care, sheltering, sleeping, feeding, it could be family reunification following a major incident such as the Highland Park tragedy of a couple of years ago, or for distribution. If we had to dispense medications countywide, this could be a point of distribution.
And do we have a goal? Is 3 our goal, or we looking for more places?
We could always use more. We don't have to use Benedictine too often. It's once every few years,
Sure.
but certainly the more the better. So we're not actively seeking, but we welcome.
Thank you. Thank you, Craig.
Member Eka.
I thought we also had disaster relief programs for a disaster at the county. I thought we had an intergovernmental agreement with COD to move over there, especially the courthouse.
You are correct, but a different purpose. That would be for continuity of operations,
Right.
where this is mass care.
Okay, any other discussion? Member Krajewski.
We could,
He's right over there.
we could use it. This may have more space, but also there are frequently events at the fairgrounds that would have to be canceled or rescheduled, but we could certainly use it.
I assume College of DuPage has a few events at their facility, and I assume the church has a few events at their facility, so it doesn't seem like.
It depends
that
on
would
what the
be an issue.
location of the actual incident is too. So it's nice to have different locations throughout the county.
It is. When we used Benedictine a few years ago,
Like Compass churches are down by Benedictine, right?
one's right down the street on Roosevelt, and then the other is in Naperville.
I mean, why not have another one? You got 2, 3, just have one here at the fairgrounds.
Okay, any other questions? Okay, all in favor? Any opposed? Okay, the motion carries. Moving on to grant proposal notifications. Can I get a motion to approve and place on file, receive and place on file item 25-1524, GPN 16-25, DuPage County Adult Redeploy Illinois Programs SFY 26, Illinois Criminal Justice Information Authority. And this is for probation and court services for $429,853. We got a motion and a second. Any discussion on this? Okay, all in favor? Any opposed? Okay, the motion carries. Okay, so next up, we're gonna go to one of today's items. This is our very own state's attorney, Bob Berlin, to discuss initial implementation of Karina's Law here in DuPage County. And without further ado, I will let you have the floor. Thank you so much for being here.
Okay, morning, Madam Chair. Good morning, everybody. So just by way of background, Karina's Law was signed by the governor on February 10th to be effective May 11th of this year. Once it was signed by the governor, we put together a team of stakeholders, including our judges, sheriff's office, police chiefs, Candace Adams in the Circuit Court Clerk's office, as well as our office. And we had multiple meetings, including on March 7th, April 21st, and May 9th, where we came up with a plan of how this was going to work. And we also were monitoring the Administrative Office of Illinois Courts coming up with their forms, but we had our own forms to go just in case they weren't ready. So we were fully prepared come May 11th when the law went into effect. One of the big issues was if a judge signs an order of protection and issues a search warrant, how is that warrant going to be transmitted to the police department? Because while the sheriff has to serve all orders of protection, Karina's Law provides that the local police department responsible for calls in that area, they're the ones responsible for serving the search warrant. And they have to do it within 96 hours. So Circuit Court Clerk's office got emails from every single police department. The police departments were requested to provide an email that they would respond to so that they can immediately notify the local police department in time to have the police department execute the warrant in time. Since the law went into effect on May 11th, we've only had one case where a search warrant was ordered and executed. It was by the sheriff's office, and I kind of want to go through what occurred in that case to show you how well everything worked. This was a search warrant that was ordered by a Cook County judge, Judge Callahan, on May 19th of this year. What happened was about 3:20 in the afternoon, Nancy Donahoe, my chief of criminal, got a call from the Cook County Court Administrator, letting her know that it was likely a judge was going to issue a search warrant for Willowbrook and to let us know so that we would be prepared for it. About 10 minutes later, we were notified the search warrant issued and it was emailed to us. And we were also provided with 3 police reports from Justice, Illinois. Justice is in Cook County. That's where the petitioner lived. The respondent lived in unincorporated Willowbrook. We transmitted immediately to the sheriff's office. They began an investigation and quickly, well, the first thing that was determined is this really wasn't Willowbrook, it was unincorporated, so it was not the Willowbrook Police. The sheriff's office was the appropriate law enforcement agency. Sheriff's office also determined that the address that was on the warrant was not correct, that the respondent actually lived about a block away. So the very next morning, we filed a motion, actually next afternoon, we filed a motion to intervene and to modify the warrant, which the law allows for. The judge put us on the call on Zoom on May 21st at 9 a.m. And at that hearing, the warrant was modified. After that hearing was over, the sheriff's office and ASA Mark Winnestoffer actually spoke to the petitioner on the phone for 40 minutes to get more information. And it was then determined that some of the information that she had provided in the fact sheet was different than what she was providing over the phone in regards to location of the weapons and how many weapons there were, and also when the last time that she had actually seen them. So again, we filed another motion to modify the warrant, and the judge actually put us on the call later that day. We went on Zoom later that afternoon. The judge again modified the warrant, and the following morning, On May 23rd at 6:58 a.m., the sheriff's office executed the warrant. When they arrived at the location, they actually found the petitioner and the respondent both present. The petitioner, unbeknownst to the sheriff's office, had called the respondent to let him know that this warrant had been signed. And fortunately, there were no issues. Fortunately, everyone was cooperative. And the sheriff's office recovered all 6 guns, 12 magazines, and 1 trigger assembly, and did so safely. The key to the execution of this was the communication that we had between not only Cook County, but our sheriff's office. They put a lot of time and work into it, and that's what the law allows for. That's why there's 96 hours for the law enforcement agency to execute the warrant, or within 48 hours, go back to court to modify it, which is exactly what we did in this case, actually 2 different times. So that is the only case that we've had so far. It went extremely well, and I can tell you that when we get the next one, whether it's the sheriff's office or any other police department, we are fully prepared. All of our police departments are fully prepared. They all participated in these meetings. And I can't speak for any other counties, but I can tell you we were out in front of it, and we continue to be out in front of it. And I'm happy to answer any questions.
Thanks, Pat. When you've got a city with multiple counties like Naperville or whatever, you guys just figure out who's going to do what, whether it's the Will County Sheriff or Kane County or us or Naperville Police.
So again, the law says that it's the police agency that is responsible for handling the calls. Sometimes that's easy to discern, but we have a number in place where the judge can actually call DuCom and give them the address and find out who's the responding agency.
Okay.
So we put that in place.
My other question was, I assume that the search warrant is issued by the judge who overhears it and who heard the case.
Typically in family court.
Okay. And is there a procedure in place for if the respondent voluntarily agrees to surrender without having to go through this? I mean, it's part of an order.
It's really up to each individual agency how they want to handle it and how they want to execute it. And it probably depends on the situation and what type of person they're dealing with, how violent of a history they have. But the police had that 96-hour window to put an operational plan in place. And that was one of the key considerations when the law was passed, to allow the police to do that, because they can't just go out and serve a search warrant without doing a lot of background work in order to make sure that there's safety for the officers.
And I know, I'm sure we're all concerned about the police departments who are executing the warrant, walking into a place and saying, "Give me your guns." So I assume that the guns that the respondent has is based on information given by the petitioner. Like, my husband or boyfriend has 6 guns, 8 guns, whatever.
Correct.
And how reliable can that be if he or she decides not to tell you that there's 8 when there's really 10?
That's really up to the judge issuing the warrant. The judge has to find there's probable cause that the respondent possesses guns, possesses them in a particular location, and that there's an immediate danger to the petitioner. And then there's a fact sheet that the petitioner is required to fill out. As we saw in this case, the police had to supplement, and actually some of the information was incorrect. They were able to get that corrected. But I think the reason we've only seen one issued is because it does require the petitioner to provide a lot of specific information to a judge in order to issue the warrant. What we have found is that we've had, we continue to have success with the firearm restraining orders, where the police go in front of a judge, they have information and they can get a warrant immediately issued. And we just had our 16th firearm restraining order this year, was just issued last week.
Thank you. Thank you, Chair.
Thank you. Member you?
Thank you, Madam Chair. So first, I just want to say thank you so much for being here to just let us know how you guys have been planning and that how you created a stakeholder group and really all the different steps that you've taken to really implement this very well. I just want to go through the process once again. You had said that this was actually a phone call that you guys got from the Cook County Administrator. And so going forward, let's say it doesn't come from Cook County, it's something that's issued here in DuPage. Would it be the job of the court administrator in that office, or is it in the courtroom, or will it be Candace Adams, the clerk, as you were stating, who's going to be contacting you and the individual law enforcement agencies?
So the law requires the court. So it would be the circuit court clerk
Okay.
who would contact us. I can tell you that we would probably get notified multiple ways.
Okay.
Through the clerk's office, and I'm sure the judge would let us know too,
Okay.
and the court administrator.
So these multiple sources of how you're getting this communication, would it be better to have a streamlined process of just one way, or is it better just to have the multiple?
We prefer belts and suspenders,
Okay.
just to make sure. And I think it worked very well, with Cook County, and I expect it'll work the same way here. Everyone wants to be sure that there's a line of communication because the clock starts running.
Right. And so you did say that the warrant was issued on May 19. You guys had multiple modifications as of May 21, May 22. So then the warrant was executed. What day? I'm sorry, I missed that.
Early in the morning, 6:58 in the morning on May 23rd.
May 23rd. Okay.
With,
Thank you.
well within the 96-hour window.
Wonderful. All right. Thanks so much.
Sure.
Member Honig and then Member Zay.
Thank you, Chair, and thank you, Bob, for your diligent work. It's nice to hear that the way that you implemented this has worked out for all parties and stakeholders. I guess my one question was, what if the petitioner can't file the form, or obviously you've only had one case, but I would assume that maybe that there are situations where the petitioner is in distress and they can't file a form, and like you said, the belts and suspenders, there's other avenues which they can get in contact, but is it a requirement that form needs to be filled out if there was just a call made to emergency operator and then it was relayed by the courts, circuit court clerk to you guys? How does that process work?
So the law requires sworn testimony in
Okay.
order for a judge to issue the warrant.
Okay.
If the petitioner is unable to provide that testimony or unable to provide a fact sheet, the police always have the ability to go in and get a firearm restraining order where the judge can issue a search warrant for the guns. And that can be done immediately. And we're involved with all of those, just like we are with these. And we make sure that the police get that warrant ASAP.
Thank you, and thank you again for your work.
Member Zay.
Thank you, Madam Chair. Well, thank you, Bob. Sounds like, and the sheriff's office, sounds like for the first one, this wasn't as smooth as it could be. I mean, it kind of alarms me that Cook County gives you the wrong address. I mean, luckily you guys do your due diligence and the sheriff's office did their due diligence, and we're not walking into the wrong place looking for firearms, which could be, a problem. My question is, well, and also with the petitioner also being there and telling the person that they're coming to get your guns probably isn't what you really want, but it's a good thing it was calm. What if when you do get there and you collect these firearms, is there any check with the state police if they have a FOID card? If they don't, what kind of firearms they have? Can additional charges then be placed on that person if it's a felon and they're having, well, we would know if it was a felon, but if they have firearms that they don't have a FOID card or anything else, can additional charges then be placed on that person?
Yeah, so to answer the first part of your question, actually the sheriff's office in this case, they did check to see, did the person have a concealed carry license, or a FOID card what the status was. And they knew that there was a clear and present danger that had been filed by the Justice Police Department. So the sheriff did all that.
Okay.
The second part of the question is, yes, if the police are in there legally, they have a search warrant for these particular guns and they find something else. Let's say they find another gun or an assault weapon that the person cannot lawfully have, and we can prove that they constructively possessed it, absolutely they can be charged. Or, you know, if they find narcotics, illegal narcotics, same thing. The police are there lawfully. Anything that's that they find during the course of the search, there can be additional charges that come from that.
Okay, great. Thank you.
Member Agal?
I just had a question about the complaining witness. Is there anything that can be done? I mean, it sounded like from your story that it was a surprise that she was there the next morning. And I think that happens a lot, unfortunately, because the battered person is a victim and under the control of the other person. But can they be prohibited from being there? Because it seems to me that makes them more of a dangerous situation.
Yeah. Again, I don't think they can be prohibited from being there. Obviously, the ideal way to do this is what happened, what the sheriffs did in this case. They actually spoke to the complaining witness. They had a 40-minute conversation with her, and they were able to get some very valuable information.
But that was the day before.
That helped them. Correct. So no way to prevent them from being here, but the fact that they're able to communicate obviously is ideal if they're able to do that, because they're always going to get more information, and the more information they have, the safer it is, not only for the police, but the safer it is for the petitioner.
Thank you.
Okay, members A, again.
I just had a follow-up. I know the undersheriff's here. I mean, when you get a call and you're saying there's multiple firearms there, I would assume you're not sending 2 deputies. I mean, there's a plan in place for the sheriff's office. I don't want to do their internal procedures, but I'm sure there's.
I'll say this, I don't know if Under Sheriff Moore wants to come up, but they were outstanding. As soon as we got this, not only did we email it to them, I was on the phone with Eddie Moore. I was on the phone with Sheriff Mendrick. And they took over, they took charge and
I mean, you're talking
more
magazines and all this other stuff. It doesn't sound like someone with just, it sounds a little bit more than just having a gun. It sounded like there was
Correct.
some
Well,
pretty big firearms.
first of all, State Attorney Berlin was way more excited about this first one than I was. We're going to be evaluating each one of these on an individual basis. We took the information we obtained from our detectives, and we decided we'd go with about a 6-man group down to this particular location. It worked out well.
So basically every situation will be different.
Correct.
Okay.
Correct.
Okay. Thank you.
I just want to add that was during the negotiations when this bill, before it was passed, one of the big considerations that law enforcement had was that time window to execute the warrant. Obviously, you're balancing the safety of the petitioner against the needs of the police. But when the police get a search warrant for an address, they can't just go out there and knock on the door and say, hey, we have a warrant. It does require a lot of behind the scenes background to ensure that they have a plan in place to keep everybody safe. Sometimes, especially when they're serving a search warrant for guns, it's a dangerous situation and it can turn sideways very quickly.
Okay, thank you. Any other questions or comments? Any discussion? Okay, thank you so much,
Okay,
Attorney
thank you.
Berlin. And now we're going to move on to our recognition and commendation for Deputy Chief Coroner Tim Rounce. I would like to invite Tim, Coroner Lucas, and her team up to the podium with me. Today, we are lucky enough to recognize Deputy Chief Coroner Tim Rounce on his retirement and outstanding 36 years here at the county. I will read the recognition and commendation and then turn it over to Coroner Lucas and her team to speak about Tim. Recognizing Chief Deputy Coroner Tim Rounce for his years of dedication and service to the residents of DuPage County and the office of the DuPage County Coroner, and recognizing Tim Rounce began his career at DuPage County in May of 1989 and has over the last 36 years has been a cornerstone of the DuPage County Coroner's Office through his leadership, mentorship, and expertise. Recognizing that over those 36 years, Tim served 4 different elected coroners, and recognizing that through his tenure, he has conducted over 17,000 death investigations and oversaw thousands more as deputy coroner. And recognizing every day he served as a tireless advocate for families and the deceased to ensure every individual received a thorough and detailed investigation. And recognizing spending countless hours in person and on the phone with grieving family members and always maintaining the utmost professionalism balanced with true compassion and empathy. Recognizing in addition to serving with the DuPage County Coroner's Office, he has been a loving husband, father, and now grandfather. Recognizing his successful career and his much-deserved retirement, even though his departure will be a loss for the office overall. Now, therefore, I, Lucy Evans, member of the DuPage County Board and chair of the Judicial and Public Safety Committee, and the members of the Judicial and Public Safety Committee, do hereby recognize and commend Tim Rounce on his dedicated years of service and wish him the best in his retirement. Madam Coroner, would you like to say a few words?
Hello, I'm Judith Lucas. I'm the coroner. I'm newly elected December, so I've only had the pleasure of working with Tim for about 7 months. And I am so grateful, Tim, that you were there. My tenure would have started out a lot different without Tim. Tim is kind of like the master chef in a really busy kitchen. So you've got everything going on, everything changes, you know, special orders here and there. You can't predict anything from one day to the other. Tim knows when to add the sugar and when to add the spice and have everything come out perfection. I have seen, you can't do our job without having compassion. So I've seen an unmeasurable amount of compassion from Tim in dealing with our deputy coroners, or the rest of our staff, with families, funeral directors. It's always a balancing act. And over the time, I've also learned more about Tim as far as he's a dedicated public service, and he's not going to be able to get that out of his blood once he retires. Speaking of blood, he donates blood and blood products. He collects the caps for the pop tops off of the can. And I don't know, did you take what, 4 or 5 big water bottles full of them over to the McDonald's house? So, and you know, he has a mother-in-law that has some health issues, and he's been dealing with her a lot. So he's able to maintain all of his professionalism at work while continuing to balance, and he's a man of integrity. What can I say? Integrity and knowledge. And you know, you're going to be a tough act to follow. That's all I'm going to say. And thank you so much, Tim. I could not have done this without you. I appreciate it. Thank you so much. And Dr. Hillary McElligott, our forensic pathologist, would you like to come up and say a few things?
Hello, I am the chief forensic pathologist at the coroner's office. I have worked with Tim for 12 years now, and he is my literal right-hand man. I call him daily from the autopsy suite to ask him questions, have him help me out with cases, and he never fails to come through for me. So he will be greatly missed.
Thank you very much. It's been a pleasure, and I hope the office goes very well in the transition.
I'm not used to doing this, so I forgot to give this to you after I read it, but this is for you to share with your family. And do we want to get a picture of it? Okay, well, the meeting ran a little bit long, but any old business? Any new business? Okay, without objection, we are adjourned.